Good afternoon. My name is Jamie Walker, and I am a tax partner with Cherry Beckert. I'm pleased to have with us today Marty Caramon, a principal in our Strategic Tax Advisory Group, as well as our national leader for employee retention credits. Good to have you with us, Marty.
It's good to be here again with you, Jamie. Thanks.
Thank you. So, for starters, why don't you give us an update on the credit, please?
Absolutely. And to do that, maybe I'll give just a quick bit of background as well. We're focusing here on the employee retention credit. We've done a podcast previously with respect to law firms. The employee retention credit, for those who may be uninitiated, is a payroll tax refund. Generally speaking, for most companies, it calculates to be larger than the actual payroll tax liability that they would have owed either in 2020 quarters or in each quarter of 2021. Technically speaking, the way I like to think about the credit is there are 5 credits. One for 2020, which is a 50% credit multiplied by the first $10,000 of eligible wages paid to any one employee during a term of what we refer to as eligible employer status on the part of a company. And then 4 additional credits, one for each quarter of 2021, which is equal to a 70% credit on the first 10,000 paid to any employee during any of the quarters of 2021, to the extent the employer is an eligible employer during those periods. Eligible employment status is something that is achieved in one of 2 ways. It's achieved by virtue of a employer having a greater than 50% decline in gross receipts in any quarter of 20 compared to the same quarters of 2019, or a company having a decline of 20%, or technically more than 20% in any quarter of 2021 as compared to those same quarters of 2019. Additionally, and we'll talk about this a bit more in depth, there's what's known as the government mandate test. So to the extent any employer is subject to government mandates, and this tends to happen more in 20 than it did in 21, to the extent they are subject to any government mandates limiting commerce, travel, or group meetings issued by a governmental authority specific to COVID-19, they also reach eligible employer status and can claim an employee retention credit. I'll leave it at that, Jamie. Do you have any questions right now?
Not at this point. Let's turn our attention and have you talk to us about the Notice 2021-49, especially as it relates to guidance on claiming the credit for the 3rd and 4th quarter of 2021, which are both quickly approaching.
Yeah, not a lot new in there other than the fact that the guidance is specific to the final 2 quarters of 2021. And if you recall, the credit was initially only a 2020 credit. And so it was then extended into the first 2 quarters of 2021. And so there was guidance that came out earlier in the year specific to claiming the credit in 2020, then guidance specific to claiming the credit in the first 2 quarters of 2021. And this guidance is really specific to claiming it in the final 2 quarters of 2021. Not a lot new in that guidance other than some clarification around the rules for some startup companies and companies that didn't have gross receipts in 2019. So not a lot new there, but additionally there, and I think more importantly, in addition to Notice 2021-49, there was a revenue procedure issued called RevProc 2021-33, which provides a safe harbor in the calculation of gross receipts for companies claiming the credit. The biggest news there is that for companies that took advantage of the PPP program, to the extent the PPP was forgiven, many practitioners, including myself, were under the impression that those proceeds with respect to the forgiven PPP loans would be treated as gross receipts for purposes of calculating eligible employer status for the credit. As it turns out, the safe harbor was provided that it is not, which provides a very, very large advantage to companies looking at their gross receipts in 2021 compared to 2020 and determining if they've had a greater than 20% decline. I think that's the biggest news that comes out of RevProc 2021-33.
All right, then. So finally, let's focus specifically on one of your and my favorite topics, and that is law firms. What can you share with us?
Yeah, I think it's good that we revisit this topic. As mentioned, we did a podcast on this earlier, and I think the point here is just to go through some of those points again, but also give the benefit of some of our experience. Law firms have started to come around to the idea that they qualify as an eligible employer for purposes of the employee credit. The reason for that is due to the fact that they had or were subject to government mandates by virtue of certain courts being closed during the period of 2020 and potentially into 2021. As a result, even though they didn't necessarily suffer the requisite decline in gross receipts, because there were court closures and the location of the courts specifically for firms involved in litigation, to the extent that they had no access to the courts, the court location really becomes the de facto location of the workplace for the law firm. As a result, they have worked to document the fact that they're eligible employers tied to the mandates that were restricting access to the courts. And it's not just court closures. We'll also think about court restrictions, think about delays specific to trials where there was a prohibition on having in-person juries. Additionally, there were certain delays in certain jurisdictions. Delays might not be the right word, but change in the way that business was done, which made the docket take a lot longer to address due to the fact that there were certain trials that were done by Zoom, and everything was just subject to a different way of doing business, essentially. Restrictions, disturbances, changing the way that law firms could operate. And those are all tied to government mandates specific to the way that the courts were allowing the firms to actually address the matters before the court. So that I think is one of the biggest things that we have seen. And I won't say we theorized it back then because we were working with some firms, but to date, we've worked with a number more of them. And here's the other thing as well. When we think about the location of the court being the de facto location of the firm, it's not necessarily just the jurisdiction where the firm is located. They may have matters before courts all throughout the country. And so we need to look at the mandate specific to each of those jurisdictions and then determine if that mandate causing a restriction actually had more than a nominal effect on the business. Generally speaking, for the firms with whom we've worked, yes, but it is an extra amount of analysis to do. Having the mandate alone is never enough. It also has to actually have a more than nominal effect on the business. But that's kind of where we are with law firms right now. And it does seem like word of mouth, the word's getting around, and firms are talking to firms. And the benefit of this program really is additional support for firms that employ individuals and keeping them on the payroll.
Any parting comments?
Yeah, there is one thing that I would like to address as well with respect to changes on the legislative landscape. Within the infrastructure bill, there's a proposal to eliminate the employee retention credit for Q4 of 2021. And so we're going to look at that and see what comes through Congress as the law is passed potentially and signed by the president. So that's something to keep on the horizon. So it may go from 5 employee retention credit calculations to just 4, one being for 2020 and one being for the first 3 quarters of 2021. But we'll see what happens. Right now it's in the law, and we'll wait and see.
Well, as always, Marty, we appreciate very much you sharing your time and your expertise, and I hope that our audience are able to glean something from your comments today. Thank you all for being with us. We do very much appreciate it.
Thank you, Jamie.